All right. Welcome, everyone. This is a horrible room. Can I just say that? For the description of this class is a discussion. And so I hope you guys will be willing to speak up. Rob has volunteered to be the runner and bring the microphone around. Here's the thing, right? So this is a case law update. They asked us, they said, hey, we need a law credit. Can you guys provide something? Sure, yeah, right? I think there's some really good and interesting cases out there. I have yet in my career, so my name is Jordan Cullmore. I'm the lead attorney in the Property Rights Ombudsman's Office. Rob Terry is our statewide land use training director. He is the AICP component of the day, so he'll provide the planner perspective. Like I say, in my career, I have yet to come up with a really good way to present cases in like a really concise way. I think the facts of the case are really important in most cases. And so with some of these, we're just going to be walking through the facts of the case, but I hope after we get through that part that you guys will want to discuss. I know you're all smart individuals with a lot of great experience, and I want to have a discussion about, okay, these cases, how do they apply to your day-to-day practice as a planner? So I'm an attorney. I've also worked as a planner. I worked as a planning technician back in the day for Provo City, and I've worked as a city planner for Linden as well, Linden City, and I'm an attorney. Rob, do you want to say anything about yourself? Or?
Sure. So my name is Rob Terry. As Jordan said, I'm the statewide land use training director. I'm the only non-attorney that works out of the Office of the Property Rights Ombudsman. So about 20 years of planning experience myself, the vast majority of that in another state whose name shall not be spoken.
It's California.
It hurts, guys. I'm sorry. That does mean, though, that I have a lot of really good examples of what not to do to pull from, right? So bringing that back home to my home state here. But as Jordan is going through these items, as he said, what we'd love to be able to have is some good feedback, some good questions, even if there's nuanced items. If there's anything in here that you're dealing with, something in your agency that you think has to do with this, raise your hand. I love to get my steps in for the day, so I'll make sure that this mic gets right out to you. And we'd want to keep it as much of an ongoing discussion throughout the session as we can.
And honestly, just like raise your hand, yell it out. That'd be great. This is the last session of the last day, and they chose us to do it here, right?
They kept you all here for the law credit. We know how that works.
Right? Okay, and then I did just convert this over to a PowerPoint, so I hope that there are no formatting issues. But if there are, I blame Microsoft. So. Okay, so these are the cases that I want to talk about. Again, there's just 5 of them. I kind of pulled it from the past 2 years. Most of them are from the Utah Court of Appeals. There is one U.S. Supreme Court case, which you guys are probably familiar with, the Sheets case about exactions, which hopefully isn't too much of a surprise for Utahns, right? But we'll get into that. Some of the topics: substantial evidence review, legislative decision-making and equal protection, exactions, appeals and timeliness, and subdivision plat amendments. I don't have any need to get through all of them, frankly, right? So if we just have a really good discussion about 1 or 2 of them, I think that's awesome, right? Make sure to get to number 5.
Do you want to start with number 5?
Yeah. That one's really short, actually. I could do that in like just a couple minutes. So we'll do that. We'll tack that on the end, and I'll make sure to get to it if I don't. That didn't make any sense, but okay. So the first one, North Monticello Alliance versus San Juan County. Okay, like I said, there's a lot of facts here, right? But I think it's interesting to kind of walk through the story, right? So if any of you guys are familiar with this situation, there have been several opinions over the years at the Supreme Court level related to due process and who can appeal, things like that. That's not what this one is about specifically. So this one relates and kind of riffs off of the McElhaney versus Moab case that the Utah Supreme Court handed down a couple years ago, and really kind of emphasizes and focuses on the importance of findings of fact and conclusions of law. So that's kind of a little preview, right? So it's a conditional use permit for a wind park. August 2015, this neighbor group, they complained to the Planning Commission that the current owner was in violation. This is a kind of a theme you'll see here, right? For the original issuance of the CUP in 2012, Planning Commission never produced a written document memorializing the terms and conditions for the CUP. So I think we've all been here, right? How many times have you gone back to someone has a conditional use permit and you're going through the minutes, you're trying to remember what was said, right, to figure out what the conditions were, things like, that's kind of, hopefully we all know that that is a thing of the past, right, and we're not doing that anymore. But that was the case here. So what they gleaned, this is a quote, gleaned from the minutes of the transcript was it required the CUP holder to incorporate as much flicker. Can anyone tell me what flicker is for a wind park?
The turbines block the sun occasionally.
Oh, so flicker, okay. So they had to incorporate as much flicker, light, sound mitigation as possible and to meet industry standards of those challenges, and they had to do it before they were going to get a building permit. That was challenged, that they had met those conditions. The commission had a hearing. The wind park presented evidence of their compliance. So from the meeting minutes, it says, studies were done relating to sound, flicker, and light. Thresholds were determined and affected lands were indicated. Mitigation for lands affected were determined and compensation amount decided. So that's really the only substantial evidence we have, right, to support a decision one way or the other of whether or not they're going to revoke this permit because the conditions have or haven't been met. So they tabled the item. 5 days later, they came back. They voted to not revoke the conditional use permit. The Planning Commission did not produce any written findings. Here, again, meetings from the minute. The other issue up for vote was whether or not any mitigation for sound, light, and flicker had taken place. This is a more subjective issue, and I'm not advancing them, am I? Someone needs to speak up when I do stupid things. Where are we? I'm looking at my own stuff here. Okay, here we are. This is a more subjective issue, not black and white. It was determined the mitigation had taken place as much as possible at this time. So the neighbor association appealed and said, hey, this isn't substantial evidence to support your decision to not revoke this permit. So then they provided a written brief to the county commission, who was acting as an appeal authority. And it decided by, so it had a unanimous vote that as much mitigation as possible had occurred under the conditions set forth. So this was their brief that they provided to the appeal authority. Referencing the minutes of the meeting, the brief didn't include any finding facts or conclusions of law. Hopefully you're seeing a trend here. The county commission conducted a record review. So this is one thing I want to have a discussion with you guys about, because as you're probably aware, state law basically says that the local government can decide whether or not the review on appeal is going to be record review, so you're just looking at the record and deciding whether or not the land use authority supported put enough evidence in there, right, to support their decision, or a de novo review from new, right? So you can gather new evidence, okay? In San Juan County, their code specifically provided for record review as opposed to de novo review. And they ultimately upheld the Planning Commission decision. So there's kind of, when you're walking through the case, it's interesting because they initially said, hey, there isn't substantial evidence here. And then they got a letter from S Power saying, we're going to lose $100 million if you revoke this permit. And then, some more information surfaced, and they said, oh, yeah, we're actually going to uphold not revoking the permit. And I don't know the background behind that and why it was done that way. But ultimately, they decided not to revoke the permit because it was supported by substantial evidence. So I think you guys know the distinction between legislative and administrative decision-making. I just kind of threw this in there. You see over there on the side, for the legal standard of review for administrative decisions, anything regarding factual determinations must be supported with substantial evidence. So that's the legal standard we're dealing with. So the Court of Appeals, it was the neighbor group appealed the decision not to revoke, and they ultimately determined the Planning Commission decision was not supported by substantial evidence. So they relied heavily on the McElhaney case that I referred to earlier. It determined that a decision of a land use authority isn't supported by substantial evidence when the body fails to produce written findings of fact. The land use authority concluded the proposed use didn't meet the code criteria. It prepared no written findings of fact. Here's a quote. While the district court noted and indeed complained about the absence of findings, Rather than remand to the land use authority, it valiantly attempted to fill the void by parsing the comments neighbors made at the council meeting. Again, something we've always all tried to do before. And the court in McElhaney said this was an error because it was the land use authority's responsibility to define the basis for its decision, not the district courts or the appeal authorities on a record review either, for instance, right? Again, I thought this was an interesting quote. Without sufficiently detailed findings, the disclosure that disclose the steps by which an administrative agency reaches its ultimate factual conclusions, the court can't perform its duty of reviewing the order in accordance with established legal principles and of protecting the parties and the public from the arbitrary and capricious administrative actions. On appeal, a court can perform its duty only if the land use authority has created findings revealing the evidence upon which it relies, the law upon which it relies, and its interpretation of the law. So I kind of just want to the sidebar here for a minute, right, and ask, okay, what are some of the pros and cons then of deciding whether or not to do in your, as far as your appeals are concerned, record or de novo review? And I put up there kind of the ordinance that we just talked about where the city can set it. Admittedly, with this kind of real strict requirement that, hey, like your decision is, the court used the word inherently arbitrary and capricious if you don't produce sufficient findings of facts and conclusions of law, right? One thought I had was, hey, well, it might be useful and wise then, because of that standard, for a local government to make sure that if they want to be thorough, that their appeal authority have de novo review, so that if they need to, they can, supplement the record essentially, right? And say, hey, this record actually doesn't contain sufficient findings of fact and conclusions of law, so we're going to do some additional fact finding. We're going to gather some evidence, and we're going to produce that so that they have that authority and ability to create a record that is going to be not arbitrary and capricious, right? Any thoughts or comments or questions, ideas, experiences?
Anybody ever run into the instance where you were reviewing something at the staff level, whether it be conditional use permit or anything that had conditions of approval with it, and there wasn't enough specificity in it for you to actually feel like you knew where to go next, if certain mitigations had been met, anything of that nature? Has anybody ever dealt with that? No? All right. Well, I guess I must be alone.
We got a
here.
hand, Bill.
Okay, I was going to say, I know that there has to be some truth to that. I've certainly experienced that myself.
So I actually don't have experience with that particular thing, but the question I was going to ask is, what is considered to be substantial evidence? On some of these legislative decisions, I understand that, if it doesn't follow the general plan, for example, that would be sufficient evidence to uphold a particular decision. So if the planning commission had included that element or that idea in their plan, would that have been substantial evidence to say this case is upheld?
So how many people produce like a record of decision when they, or anything like that? To me, that is the biggest part of what we're talking about when we say findings of fact and conclusions of law, right? Because all this other information you're talking about, so like the general plan, the general plan doesn't support it. Depending on the decision, yeah, that might be substantial evidence, right? In the administrative context, it has to be something that's pretty mandatory, right? And factual and credible and meets all the requirements, right? So substantial evidence, to answer your question, right? It's anything that's sufficient to convince a reasonable mind to support a conclusion, right? But again, it has to be factual, it has to be credible, it has to be from an expert if it's something that's technical, for instance, right? Like we're talking about traffic and those types of things. Does that answer your question? Yeah. Okay.
Yeah, and my experience, just to add to that, has been on the substantial evidence portion to try to be as specific as you can be without, going too far. But, a term just like it doesn't meet the regulations within the general plan might be too broad, depending on who might be the entity that's going to review that and look at it. But if you were to say that it's counter to policy 1-34 within the general plan, or it doesn't meet this standard according to the general plan in this section. Trying to point to those areas to give as much specificity as you can, to me, just simply strengthens that reasoning. And then it helps that what's supposed to be a reasonable person be able to come to that conclusion, it helps point directly to what that is. So,
Rick Plen from the Office of the Property Rights Ombudsman.
The way that I always talk about this is, I mean, I think in the plainest terms, when we talk about substantial evidence, the court is just telling us, show your work. Just show your work. Because
It's like your math
in
teacher.
this case, in the McElhaney case that was referenced before, the McElhaney case was about, the commission, they all took a vote and made a decision, but they didn't explain the reasoning, right? And then this is kind of the same thing. There was a decision made, but no record produced. So it's like, we don't, the court's job is to review these decisions to determine whether they're made correctly. And if they don't have any reasoning to, behind these decisions, they don't know, how to, so they say, if you don't show your work and explain why you made your decision, then it's inherently arbitrary.
Yeah, and to support what Rick is saying, so these are the kind of the lines that were relied upon, right, from the meeting minutes to say, here's the substantial evidence. And the court said, they cited those statements, they said, these cursory declarations are wholly inadequate. They certainly fall well short of being sufficiently detailed findings that disclose the steps by which an administrative agency reached its ultimate factual conclusion, right? So they didn't show their work. Accordingly, neither the commission nor the district court could perform its duty of reviewing the administrative decision in accordance with established legal principles and of protecting the parties from arbitrary and capricious action. So I just threw this up here because this was actually a provision that I would use in prior advisory opinions before McElhaney, pre-McElhaney, right? To say, hey, yeah, it looks like there is substantial evidence. And this just basically says like, hey, there were meetings, there were discussions, it looks good, right? So that was enough to convince the Utah Supreme Court in 1999 that there was substantial evidence to support the conclusion. But that is not the case anymore. So you need to do better at showing your work. So the takeaways, they decided against revoking a conditional use permit for failure to comply with previously imposed conditions. They failed to produce written findings sufficient for appellate review. And like I said earlier, the court said, thanks. Thank you. So its decision was unsupported by substantial evidence and was therefore inherently arbitrary and capricious. Okay, I'm going to remember to advance. All right, any other questions, thoughts, comments? Guys, come on, this is riveting stuff. This is the kind of stuff you want to be doing at 4 o'clock on a Friday afternoon. Yeah. Okay, so this next one I thought was pretty interesting because in the office we get the call a lot of, hey, so now we're shifting gears, right, from administrative decision making now to legislative decision making, where your decision just basically has to be reasonably debatable to be in the public interest, and arguably you don't need to even provide that many findings, right? Like the court just has to be able to look at it and say, is it reasonably debatable that the decision to rezone this property or to not rezone this property is in the public interest or compliant with LUDMA, however you want to frame it, right? But we get the question a lot. Hey, if we make a zoning decision, you've probably heard this. Does that set a precedence, right? So that we'll have to make that same zoning decision for the next person, right? And this kind of explores that and gets into that in the context of landfills. So I like to call this one the tale of two landfills. Kudos to the photographer, guys, right? I mean, does that not make a landfill look gorgeous? It's beautiful. So we got Promontory Point landfill, and then there's a group called Molding Investment, their landfill. So you kind of have to walk through the timeline again, right? 2003, Promontory Point asked for a CUP. So at this point in 2003, the zoning allowed for a landfill. Promontory Point went and sought a CUP There's some information about it.
Yeah, advance.
Not advancing again. And then in June 2003, they had a public meeting. There was some public opposition, concerns that you'd imagine, right? Access, public safety, environmental concerns. But Planning Commission looked at it and said, it complies, right? Because now we're talking about a conditional use permit. So they recommended approval. The city council, as the land use authority, unanimously approved it. It wasn't subsequently put into operation. Conditional use permit expired in 2009. Around 2009, the county commission passed an ordinance requiring all landfills to be located in the new MSW, Municipal Solid Waste Zone. The new owner of PPL applied to have the property rezoned. There was a single comment in the public hearing asking about land value. The planning commission voted to recommend approval. They considered and approved the request in January 2010. Again, just one more citizen expressed some concerns. And then in 2011, September 2011, they got a DEQ permit to operate a landfill, but didn't proceed to obtain another conditional use permit from the county. So now moving, oh, excuse me. Yeah, that was primary point. Okay, so now moving, so we're in 2011 now, right? And this is all sequential. So then in 2014, Molding requested to have 225 acres, still not advancing, to the MSW zone with the intent to operate a landfill. And they were a lot more on the ball, right? So they applied for their DEQ permit on the same day. At that time, the county had one landfill. PPL still wasn't operating. So May 2014, the Planning Commission considers their application. There's a lot of public comment about concerns related to landfills. And they tabled the application so that they could kind of address some things. March to August of 2015, so back to PPL, right? They kind of explored with the county the idea of either selling or doing a profit sharing agreement. That ultimately didn't come to pass, so it remained private. November of 2015, the county commission, and this is important, which wasn't composed of the same commissioners, right, who approved the PPL zoning request. They passed an ordinance reclassifying the MSW to the solid waste zone. And due to an oversight, I'm sure you've never seen this before, right? The PPL zone was not updated to reflect the change. June to July of 2016, the Planning Commission and County Commission rezoned PPL to SW in light of that oversight. And in March 2017, the Planning Commission approved a second CUP for PPL. Now moving back to Molding in 2019, they finally got their class 1, thank you, land use permit. In August 2020, the Planning Commission again considers their previously tabled 2014 zone change, and they recommended denial, right? And they gave their reasons for why, kind of things you would expect, right, related to a landfill. September 2020, the Commission unanimously denies the rezone based upon similar findings, right? Location, there's flooding, there's aquifer recharge issues, seismic activity, litter, smell, traffic, value of property, not a need, right? Especially when considering existing capacity in the county and the adverse effects, public opposition. And so October 2020, Molding sues the county and each county commissioner individually, alleging the county violated its equal protection rights under the Constitution. They'd violated Molding's rights by treating them differently from other similarly situated parties, namely PPL, and that they had done so, oh, there's a typo, with ill will and without any rational or legitimate basis. Okay, so when we're talking about equal protection, it's a constitutional principle, right? Requires that similarly situated persons be treated alike. It's unconstitutional to single out one person or group from among a larger group. Molding, in this case, was alleging what we call a class of one claim, and that's proper when the plaintiff alleges that it has been intentionally treated differently from other similarly situated, and that there is no rational basis for the different treatment, but there isn't a class, right? It's just an individual. Oops. Time are we doing? Okay, 4:21. Okay, so talking about an equal protection claim, so this is all things that the court talked about, thank you. It's insufficient to allege an uneven enforcement of the law. What is required is a showing of a totally illegitimate animus toward the plaintiff and the defendant. To prevail on a claim that the government treated the plaintiff differently from others similarly situated, the plaintiff must identify comparators that are similarly situated in all material respects, which is a substantial burden in the land use context because each property has unique characteristics. So the court talked about how there wasn't a lot of Utah case law, but they quoted from the First Circuit, of the federal First Circuit. Plaintiff must show an extremely high degree of similarity between themselves and the persons to whom they compare themselves, and the similarly situated requirement must be enforced with particular rigor in the land use context, because zoning decisions will often, perhaps almost always, treat one landowner differently from another. So here were the similarities and the differences that they identified, right? They're both in Box Elder County. They're both publicly opposed on similar concerns. Both weren't originally in that landfill corridor that they needed to be in before the rezone request. But then look at the differences, right? And really, what the court basically said is that you have to have a comparator that is similarly situated in pretty much every respect, right? So because there were differences, it was actually a really easy decision for the court to say no equal protection claim, right, or violation. It was filed at different times. There were different decision makers, the commissioners. And then even the fact that one application was approved before the other, they said is sufficient reason, right, and a sufficient difference between the two. Other potential differences that they didn't even need to get to that the county had brought up were location, topography, and level of public opposition. So the takeaway is that, and again, this is that quote from the First Circuit, you have to show that the government treated the plaintiff differently from other similarly situated persons and must identify comparators that are similarly situated in all material respects, which is a substantial burden in the land use context because each property has unique characteristics. So that's the rule, right? As I've thought about it, I mean, in the residential context, you might need to be a little careful, right? Because if you have two parcels right next to each other and they really are pretty similar in almost all respects, and you say yes to one but no to the other, that kind of is starting to rise to the level on the same night in the same meeting, for instance, right? That might be a situation where you're starting to get closer to, very similarly situated parties, kind of a thing. Any other thoughts, comments, questions? In the back here.
Just that seems sort of off that they would have to apply at the same time and be heard by the same commissioners. Those differences seem unusual, and then they're trying to make a decision about whether they treated one application fairly, given that it's a commission representing the county. Do you have thoughts about whether those are good differences?
Which one specifically?
About the first two bullets, if you go back on the slide.
Different times and different commissioners?
All the same people sitting on the dais at the time that either one of them was heard or filed at different times?
Yeah, it's a great question, and I think a lot of it kind of relates to kind of the deferential standard that's afforded to zoning anyway, to an extent, right? To this point, what they said in the opinion was, the line was there were different commissioners that very well could have had different agendas. So they were just very straightforward to say, hey, maybe one commissioner, thought that they were pursuing a certain agenda related to what kind of commercial development they thought was best for the county, which is different from another. And to the court, right, as far as equal protection is concerned, that was sufficient, right? Equal protection, when we're talking about constitutional equal protection, usually we're talking about like protected classes, right? Or fundamental rights. And I think in this case, an equal protection claim, they're going to be really deferential to the legislative decision makers because we're not dealing with either of those situations, fundamental rights or protected classes, right? As long as the zoning allows some beneficial use of the property, for instance, you know what I mean? But it is an interesting point, and yeah, I was, a little surprised as well at how deferential they were to say, hey, like, if you want to make out a constitutional equal protection claim, you're going to have to show like some really high fidelity here, right, between the situations. Does that make sense, or is that helpful? Great question. So the question was, does this only apply to legislative or could it apply to administrative? This only applies to legislative, for sure. Because in administrative, yeah, you have to treat at that point, you're just applying the code and supporting with evidence, right? So the deferential standard goes away, right? Good question. Any other thoughts, questions, comments?
I think in line with that one too, when you're talking the difference between administrative and legislative there, it almost links with the last question that was had about, that just seems kind of odd about same commission, same meeting, same everything. But I think on the administrative side, that argument or that thought process would be a lot more in
Absolutely.
line with that, right?
Yeah.
Because then, regardless of what staff member it was, what planning commission was sitting in place at the time, the rules are what they are. And so that to me would be, again, the difference if this had been challenged as legislative or administrative.
Yeah, all that would be really important stuff in the administrative context. It doesn't matter who's making the decision, right? But the courts basically said that, yeah, when you're making legislative decisions, that one was actually really surprising to me that they were that explicit in saying the agendas of the elected officials make a difference, so. Okay, the next one, Sheets versus the County of El Dorado. So this is an exaction case. I'm not going to go through all this, but essentially, if you want the slides, I can send them to you. How about that? Send me an email. So I don't know how many of you guys are all familiar with this one, but in California,
Sorry.
there's been an ongoing debate throughout the country of, okay, when we're talking about exactions, and so everyone knows, I'll go here first. So what is an exaction? It's a mandatory contribution required by a government entity, thank you, as a condition of approval for development application. It can include dedication of property, construction and dedication of public improvements, money payments, including impact fees. So the way I kind of think about it, the clear-cut way, is anything that a city requires a developer to construct, and after the project is all done, the city owns it, right? Those are exactions, essentially, right? Because you are requiring the developer to contribute public infrastructure, or their private property as public infrastructure, right? So there's takings implications. And there's a test, as we all know, the rough proportionality test. It's intended to ensure the exaction is reasonable and the development pays for its own impacts, but no more. And so there's a more technical test, right, that was handed down by the U.S. Supreme Court, and now it's in state code. But essentially, it has to do three things. The requirement has to serve a legitimate government function. It has to provide a solution to a problem that the impact of the proposed development creates, and the cost to the developer is about the same. It has to cost the developer about the same as it would cost the local government to address the impact itself. And so this test, right, it's kind of this heightened test that any imposition of an exaction, any requirement to build a road, to put in a sewer, to put in a water line, to public landscaping, right? All of these requirements have to pass this exaction test. And for the longest time, there was this discussion about, well, if it's in your code and it's legislatively imposed, do you have to apply the exaction test, or is it only when you have like a fact-finding situation and the requirement is imposed on an ad hoc basis administratively, right? And a lot of states, including California, would say, oh, you only have to apply the exaction test when you're imposing the requirement administratively. But if it's legislative, if it's in your code, then you just apply the more deferential standard of, is it reasonable, right? Is it a reasonable requirement? And because most legislative decisions have, as we've talked about, deference afforded, right? That they're reasonable, kind of a thing. And so California, they had this requirement that everyone had to pay this impact fee. They were very overt in acknowledging that, hey, like, we didn't actually do any sort of an assessment of impact here. Like, we just need the money to pay for these facilities, and we're going to impose it on anyone, right? So the case was brought, and I think Justice Gorsuch, I'm really bad at this, said that in the end there was radical agreement. So ultimately all the parties agreed that, yeah, actually it applies to legislative and it applies to administrative decision making, which is something that the Utah courts in the BAM cases had decided several years ago, right? That legislative and administrative decisions are all subject to the rough proportionality analysis. But there's also, and I put this in there because I thought some land use decisions fall neatly within the legislative adjudicative categorical framework. Most do not. One frequently cited scholarly treatment on the topic notes that in reality, the discretionary powers of municipal authorities exist on a continuum and seldom fall into the neat categories of a fully predetermined legislative exaction or a completely discretionary administrative determination. But the reality is now that it's very clear both on the federal and the state level that regardless, if you are imposing an exaction, then you need to apply the rough proportionality analysis. So the takeaway is if a requirement in the code when applied to a specific development proposal requires the property owner to address impacts that are arguably beyond their own, then you have to engage in an individualized determination of impact to figure out whether the condition satisfies the rough proportionality test. The concern we always bring up when we say, well, hey, you apply your code, you have to, the code says that we need to require the developer to build this road, right? And then we do the analysis and say, well, actually, that's an arterial road or that's a collector road, and it's offsetting more than just the developer's impact. So you can't impose that requirement, right? And the response we always get is, well, but we have to follow the code, which is true, right? There's a provision in state law that says cities have to follow the mandatory provisions of their ordinance, right? But the counterpoint is ordinances can't violate the Constitution or constitutional principles, right? Does anyone have this struggle or question or had experience with how to address that situation if you run into it? Yes, no, maybe so.
I have it, I just think that it's going to be we have to be cognizant of it.
Yeah.
And to make sure that we're fair and we follow the Supreme Court ruling, make sure that constitutionality is followed. Because I think we've relied on that concern for so long.
Yeah, and it can be tough, right? And I'll tell planners, hey, or attorneys or whoever, right? If you're in a situation where you're in a DRC meeting or you're talking about a situation or you send back, comments and say, hey, I have to do this, and the response from the developer is, wait, but our development doesn't need that. That should be your red flag, right? That doesn't necessarily mean that you can't impose the requirement and that your requirement isn't going to be a constitutional exaction. But that is what, in my mind, should trigger the question, right? Should we be imposing this exaction, or is it requiring the developer to offset impacts beyond their own, right? Does that make sense? Hopefully.
I got a question on the side of development impact fees. When you're talking administrative items that go toward that fees identified that you're passing along. When you do your development impact fee analysis to then establish your fees, right, or to recertify the fees, does that then count as any of that substantial evidence or anything that no longer becomes a one-off on an item, correct? From a legal standpoint.
Yeah, so if you're following, yeah, and again, so impact fees, that is the intent of impact fees, right? Is to try to offset each individual proposed development's impact on what they contribute to system improvements. And if you're going through the analysis of the Impact Fee Act, and you got your impact fee facilities plan, and you got your impact fee analysis, then the number that spits out, right, should represent their share fair contribution. And the whole idea behind the Impact Fee Act is they're trying to get to a fee that does comply with the rough proportionality analysis.
Yep.
Is that?
Yeah, I just wanted to, that's actually a very common question that we get, is that people will say, looking at this development, here's what our impact fee analysis says. What if there's items that we think actually go beyond that? And to let them know that you can live in both of those worlds at the same time. You just have to have the appropriate amount of analysis that is conducted, your overall analysis that was done for the impact fees themselves, and then if there are specific items to that development that require something more, then there needs to be additional and specific analysis associated with that rough proportionality.
Okay, thanks, Rob. Yeah.
Who bears the cost of making the individualized determination?
Uh,
Assuming that there's going to be some sort of engineering study or something involved, is that the developer or the municipality?
So it's it's a great question, and I get that one a lot. It's the local government's burden to perform the individualized determination, right? At the same time, if you as part of your process, right? I mean, you probably already require certain traffic studies and things like that, right? But admittedly, I would say that if the local government produces a traffic study, we'll use that example, right? That says one thing and you disagree, then my sense is it's probably going to be the local government's burden to go find some other evidence to support their conclusion, right? Good question. Any other opinions about that, or thoughts or comments? Yeah. Yeah. Yeah, that's a really good question. And that's kind of, I think, probably why the number one topic that we get advisory opinion requests on is exactions, because there are very clear exactions. I'll often, when I'm doing a more detailed exaction presentation, I'll put up a map of a master plan development, right? And everyone, I think, would agree that the local roads within a master plan development are project improvements, right? And everyone would agree that I-15, right, and your interstates and even your larger collectors and arterials are going to be system improvements, right? That you shouldn't require a single developer to build, right? But it's kind of on the fringes, right? Where it's like, well, hey, like you said, I mean, the development is having an impact on it. It's even an on-site within the development, right? But it's nonetheless like a regional park, or, so there's a lot of gray area between what is a system and a project improvement. And I don't know that I have a categorical answer in every case, right? Other than my recommendation is to try to work through it, right, with the developer. Like, acknowledge that, hey, this has system characteristics, right? And see if you can't find some sort of an upsizing agreement. I don't know if I'm answering your question, but is that helpful?
Just saying
Okay. Yeah, it does, right? And everyone hates that lawyerly answer of it depends, right? But I do really think you kind of got to dig in and decide, okay, what is the impact of the development proposal, and what is a more, system-wide impact, and then hopefully you can figure out a sweet spot with the developer. So, was there one over here? Maybe Josh? Yeah. Right. Yeah. Yeah, I think that's smart, and it's a really interesting question, because everyone, and I have regular discussions about, okay, I get that, like, I can impose requirements that they provide project improvements, and I can't make them do by themselves system improvements. But, what is the baseline that we're going off of? And that's basically what you're talking about, right? Well, what if I make the project improvements really, really fancy, right? And really, really nice, And there's a 1980s case. What's that? The level of service, exactly. Yep, yeah, exactly. So who sets the level of service? And the answer is that the city does, right? The city sets the level of service. There's a 1980 case, Call versus West Jordan, where that's questioned, right? Like the city has this requirement. I think they were requiring a developer to dedicate, it was either 7 or 10% of their land to parks and open space. And the question was asked, like, is that a reasonable requirement, right? And that was the standard. The court said, well, it has to satisfy the constitutional reasonableness requirement. Who determines reasonableness, right? And so, and there's discussions, right? Like there's discussions in the state right now of who does set the baseline. I mean, we've seen it, right, with roads. You say now you can only require, except for certain exceptions, 32 feet of asphalt, right, for a local road. That's the state stepping in and setting the baseline, right? Because they, however you want to frame it, right? They decided it was a more statewide issue. They didn't trust the local governments to set their own reasonably, however you want to frame it, right? And really that's my response is like, just make sure you're checking that box of trying to ensure that your level of service you're setting is reasonable. Otherwise, you might see more situations where they're developing statewide standards about what the level of service is for, a local road or an arterial or a downtown area. Because, yeah, as of now, as far as who sets that level of service, that standard to determine whether or not you can impose it, that authority still remains with the local governments.
So, similar question regarding planning developments, other negotiated zoning districts. Typically, those types of zoning designations are associated with a trade-off or a compromise.
Yep.
With the developer. Does this same test, I guess, apply to those standards, or do those, as long as they're agreed to by both parties, is it okay? Or what happens if they're agreed to initially, then the developer later changes his mind and says, hey, sorry, this seems very unreasonable. Could you speak to that?
Yes, and that's an excellent question, because now we're getting into, is it a bargained for agreement or is it an imposed requirement, right? Because if it's a bargained for agreement and it meets all the standards of a contract, right? There's an offer, there's acceptance, there's consideration, each party is giving something, and there's a meeting of the minds about, yeah, we're entering into a deal. If you can show all of that, then yeah, like sky's the limit technically, right? As far as what you can negotiate a developer to contribute. But if you get into the situation where this is a hazy line, right? It becomes a requirement, an imposition of a condition, as opposed to a bargained for negotiated agreement. That, in my mind, is when your exactions analysis kicks in, right? Does that make sense? Yeah. Do we have a question? Nope, just adjusting things. Okay, this is what I was hoping for. This is good. Rob, any other thoughts or? Nope. Yeah, I'll give an open invitation, right? We talk about exactions a lot in our office, and if you have a situation that you want to bounce off of, please give us a call. We have about 5 more minutes left, right? I don't know, Mike. Maybe we're not going to get to. Let's see. How can we shorten this up? So this one. Thank you. Gosh, I am so used to just having it plugged into my computer. You know. We'll skip this one. This one basically relates to, so there was a Love's truck stop. Here, I'll just say this. So there was a question about whether or not, let's see if I can find the right slide. This is what I thought was really interesting about this one is what is the requirement of an appeal? So this is a situation where the county, Love's truck stop was coming in. The county was looking at changing some zoning. So Love's caught wind of it. They submitted their application, right? And then a neighbor group said, well, we don't think the application is vested. And they were trying to figure out whether or not the county had made a decision on the application. And there was a lot of communications, but none of them were super formal. And there was this letter that basically said from the county to the truck stop saying, hey, yeah, you've submitted everything. You guys are good. You don't have to worry about anything else at this time, right? And this neighbor group was trying to figure out the whole time whether or not the county had made a land use decision, right, that was appealable. And so they submitted a grandma request, and they got back this letter that said, yeah, it looks like you got everything in. And then the letter they wrote, let's see if I can find the, so here's kind of what the letter said, right? So they kind of walked through and said, hey, we don't really like what you've produced from the grandma report. They talked about some of the code provisions they thought had been violated. And then this was conclusions and request. And they said, the county must comply with its own zoning ordinance. I request that the county commission investigate this matter immediately and issue a decision as to whether, 1, the sketch plat application has been determined by the county to be in compliance with the zoning ordinance, and 2, whether the commission considers Love's sketch plat application to be a land use application that has been deemed complete as of the effective date of the temporary moratorium ordinance, as well as Utah code. So the question comes up, is that a formal appeal, right? Have they submitted an appeal of a land use decision? What do you guys think? They don't use the word, they never use the word appeal. So here was the relevant language, right, from the, and it basically tracks state law, right? So the court looked at it, said any person affected by the land use authority's decision applying an ordinance may appeal that decision to the appeal authority by alleging there is error in any order, requirement, decision, or determination made by the land use authority in the decision applying the land use ordinance. And the court said, yeah, it was. That was an appeal. So this is kind of interesting to me, right? Because they didn't submit a formal appeal document or anything like that. But because they had said all the right things in this letter, that was a formal appeal. And they got to move forward based upon that. So just something to think about, right, as you're working through different things with your land use decisions and your appeals. We won't worry about that. Okay, we're going to get to it, Mike. So 6 Blue Bison versus Alpine, 455. I haven't kept you guys over, right? Have I? Okay. This, and maybe this.
That's Jordan's favorite slide, by the way.
Yeah, this one right here?
Yep, that's the one, right?
Okay, yeah, because every time this issue comes up, I just think of platypuses, right? Like subdivision plat applications, they're platypuses, right?
Is it platypi? Does it go to platypi once?
Platypi?
I don't know.
That's a great question.
It's Friday afternoon, guys.
So again, this was a situation where we're in Alpine, someone has a plat in place, and they requested an amendment to the plat application so that they could punch a road through the development and get access to a development that they're doing in Draper City, right? And they needed another access, is what I kind of gleaned from all this. And so the question comes up, okay, well, and they were pretty much compliant in every regard with the code. And the staff even said, like, yeah, if this were a brand new subdivision application, they would be entitled to approval, right? But the neighbors and the city were worried about the traffic that would come from this road. And so ultimately the decision that they made was, this road isn't depicted in the general plan. Which, again, like, is every road depicted in the general plan? Like, this is pretty straightforward stuff, right, to anyone who works in the space. But they said, you know, it's not in the general plan, and so we're going to deny it. And the legal principles that they used is the fact that in state law, Utah Code provides that the land use authority may approve the amendment of a plat if the land use authority finds that there is good cause for the amendment, and no public street or municipal utility easement has been vacated or amended. Baker versus Park City was was another appellate court decision a little while ago, and that's what this case relied on. They said the word may is discretionary rather than mandatory. Therefore, the application for a plat amendment do not enjoy a presumption of regularity with an expectation of approval. Look at that, I figured it out with the last slide. I got it to the right place. So because LUDMA does not define good cause, municipalities necessarily have some discretion in determining what constitutes good cause for a plat amendment. As such, even though an application to amend a plat may comply with all applicable land use regulations, substantial evidence may nevertheless support its denial. And that the court determined that this finding that the city made that, well, this road isn't depicted on our general plan, that was substantial evidence to deny the application. Like, this blows my mind, to be completely honest with you, right? That we're talking about an administrative decision, and everything in there looked kind of like legislative decision-making, right? Like, well, we don't really think this is a good idea, right? And the court said, yeah, that's substantial evidence to support a good cause determination, right? And the court even said, they kind of flipped the script and said, while the code says you may approve it, the corollary is that you also don't have to approve it if you find good cause to not approve the plat amendment. So, I mean, my advice to people, honestly, is just be careful, right? Like, I would personally advise, if I were, I'm not a city attorney, but if I were, I would encourage people to treat subdivision plat amendments the same that they treat initial subdivision applications, right? But there is a situation, I mean, yeah, that it is what it is, right? It's the platypus, as I call it, the subdivision plat amendment. So, any thoughts, comments, insights there from anyone? Okay, we're at time. Thanks, guys. There's Rob and my information if you want to give us a call or send us an email about anything. So, I know, me too.